Well, good afternoon, everyone, and welcome to another episode in our Greenway Chambers CPD Super Series. My name is Frank Hicks, and I'm joined today by Brienna Anderson, and we are going to be providing you with some information, statements, and hopefully good advice concerning construction law. Now, I know the seminar today was billed as a year in review, 2023. Quite frankly, that occurred when we were told we needed to get a title in about November last year, and we thought that's as generic as can possibly be and will be sufficient to get at least some people relatively interested. So I'm sorry if we don't give you a comprehensive survey of construction law of 12 months from January 1 to December 31 of 2023. But I do think we've got some interesting cases and indeed a particularly interesting piece of legislation that we'd like to speak to you about today. I'm going to be talking about that legislation, which is in fact something of an omnibus bill in that it comprises amendments to a series of acts with respect to construction, and in particular the Home Building Act and the Building Product Safety Act. And I'll be detailing those provisions because that Amendment Act passed both houses of the New South Wales Parliament in November 2023 and was assented on 11 December 2023. So it will be in force for the upcoming year. So rather than give you a look back and what happened in 2023, consideration of that legislation will allow something of a prospective view about what is now involved, and in particular what's called the chain of responsibility and the duties that various people have with respect to building products and their use in New South Wales. In addition to looking at that legislation, which will probably take a little bit of time and may involve a degree of reading on my part, I also propose to talk to you about 5 decisions, one of which was very recent, last Friday, but I'll be addressing you on the Pathburn Court of Appeal decision and the findings with respect to the availability of the apportionment defence in the context of the duty under Section 37 of the Design Building Practitioners Act. I'll also be speaking to 3 decisions concerning the Security of Payment Act, which were heard in the Court of Appeal. I was involved in 2 of them. I won, 1 of them I lost, so 2-1. I'll take that any day of the week. But in any event, let's move on and discuss the Building Legislation Amendment Act. I'll ask Brienna if you could click. There we go. As I say, it was passed on the 21st of November and was assented on the 11th of December. Now, the objects of the Amendment Act are stated to be as follows. Firstly, to enable building defects in homes to be investigated before a complaint is made, including new powers to enter sites, order rectification, or to stop work, and to take action against licence holders. Secondly, to introduce duties upon persons in the building products supply chain to ensure building products are safe and suitable for their intended use. Thirdly, to amend the legislation relating to strata schemes to enable the percentage of contract price required to be provided by a strata developer as security to be prescribed by the regulations and to make provision for decennial insurance. Fourthly, for the immediate suspension of registrations of building certifiers and practitioners in certain circumstances where a show cause notice has been issued under respective legislation. And fifthly, to facilitate the sharing of information with government sector agencies under the Building and Development Certifiers Act and the Home Building Act. Now, I'll start with the amendments to the Home Building Act, and this introduces a new Part 3B for the investigation of defects. Now, I'll roll through the relevant provisions in some detail, but Section 49A allows the Secretary to authorise a person, described as an inspector, to investigate residential building work. And there are various provisions, I won't go into all of the detail about them, concerning how that inspector carries out that task. But once the investigation has occurred, Section 49B, that is under the Home Building Act by these amendments, allows the Secretary by written order to give to a contractor specification that the contractor takes steps to ensure that a defect in residential building work or damage is rectified where the Secretary is satisfied that the work is defective, the work done by the contractor is being carried out in a way that could result in a defect. So obviously these are orders that can be made in the course of the construction work itself rather than waiting until the end of the project. Thirdly, if the contractor or the person undertaking the work on behalf of the contractor has caused damage to the structure or the work, and fourthly, as a consequence of that work, a structural work has been damaged. Now, the terms of the rectification order are quite broad. They may specify conditions to be complied with. They may be made as a staged rectification order, but they must specify a date by which the requirements of the order must be complied with, or a date on which the requirements of each stage of the work are to be complied with. Now, there is a requirement for written notice under Section 49B(3) before such an order is given, providing details of the matters addressed, and written submissions may be made to the Secretary concerning the terms of the proposed rectification order that is to be made, or at least is proposed to be made. Section 49D allows appeals to the tribunal in respect of rectification orders. So if such an order is made, one can challenge it, or a contractor may challenge it. However, there's two matters to be noted with that. Firstly, the appeal with respect to a rectification order must be made within 30 days. And secondly, the lodging of an appeal does not operate as a stay in respect of the rectification order unless the tribunal otherwise directs or fines. So that if you have a contractor who has received one of these orders despite their written submissions to the Secretary saying why it shouldn't be issued, then you have to move fairly quickly. And if you want to allow the work to continue, which would often be the case where a work order such as this was made in the middle of a project, you would also need to seek urgent relief or directions from the tribunal to allow the work to proceed. Now, the Act doesn't specify how that sort of application will be dealt with or what factors will be involved, but I would expect that it would be the usual sorts of provisions and evidence associated with an interlocutory application to demonstrate why, at least on a prima facie or reasonably arguable basis, that the order was unnecessary and that work could otherwise proceed. It is an offence, I should say, to fail to comply with a rectification order, and with many of these provisions introduced by the amendments, it arises or is punishable through the application of penalty units. I don't know what a penalty unit is these days. Let's say it's $400, I don't know. But anyway, whatever it is, 3,000 of them in the context of a corporation and 1,000 of them in the context of any other person. In a similar way, the amendments to the Home Building Act in a later part, Section 129, allow for stop work orders to be issued against a developer. And the basis for a stop work order against a developer is to order the developer to ensure that the building work stops if, in the Secretary's opinion, the building work is or is likely to be carried out in a way that could result in significant harm or loss to the public or to occupiers or potential occupiers of a building to which the work relates, or significant damage to property. There's also an alternate circumstance in which such an order can be made where there's a change in the principal certifier or building practitioner for the work, and in the Secretary's opinion, the building work is being carried out in a way that could prevent the valid issue of an occupation certificate. Again, these are orders that the legislation has determined should be made in the course of works to stop problems arising before they actually manifest at the conclusion of a project or works. So, again, There are various details about stop work orders provided for in the amendments, including when they take effect, how they're to be communicated, the need to also give notice to the local council or the principal certifier where a stop work order of this kind is actually issued, and an obligation to comply with the order, again, subject to those penalties involving multiples of penalty units of 3,000 and 1,000. As with the orders associated with the rectification work issued to contractors, it is possible to appeal to the tribunal against the stop work orders. However, again, in the same way, one has 30 days and it does not operate as a stay without something more being sought or procured, I should say, from the tribunal. Next slide, please. The next suite of amendments that are made by this Building Legislation Amendment Act concern, as I say, the Building Products Safety Act. And I'll try to move through these a little bit more quickly, but they are important, particularly for those who represent or are sought to give advice to people who are within what's called the chain of responsibility for building products. Part 2A is introduced to the Building Product Safety Act, and it establishes what is described in Section 8B as a chain of responsibility for a building product. And persons who are in the chain of responsibility is a person who designs or deals with the product and knows or reasonably ought to know that the product will or is likely to be used in a building. It includes a person who prepares a building design that incorporates or recommends the use of a product in the building. And it includes a person who uses the product in the building. There's also an additional provision for the regulations to identify a person who would be in the chain of responsibility. So it's quite clear that the legislation is trying to identify potentially responsible persons everywhere from conception to construction. It also specifies in the legislation that a person might have multiple or concurrent duties wherever they fit in. They may have several or different roles in that chain of responsibility. And Section 8D sets out what the duty of a person in the chain of responsibility is. And the duty is, as far as reasonably practicable, and is to take into account risk management factors in relation to which the duty relates. Now that duty, there are various duties that I'll come to, including ensuring conforming products and compliant users, a duty to provide information, a duty to notify the Secretary of Non-Compliance, and duties in relation to building product recall. But going back to the definition of duty and what's described as the risk management factors, what a person in the chain of responsibility has to do in the context of those variable or various duties, I should say, that are now stipulated in the Act, is to consider the likelihood of the existence of a safety risk or non-compliance risk, the harm that could result from that risk, what the person knows or what reasonably ought to know about the risk and ways of removing or minimising the risk, the availability and suitability of ways to remove or minimise the risk, the cost associated with the ways of removing or minimising the risk, including whether the cost is grossly disproportionate to the risk. So those are the factors that need to be considered. And as I say, there are a series of duties which I'll run through now. Next slide, as I say, there's a duty to ensure conforming products. And that duty is to ensure that a non-compliance risk does not exist in relation to the product. There's a duty to provide information under Section 8F. That has various provisions to it. I won't read them out seriatim given the constraints of time. But essentially, it is an obligation to ensure that sufficient information is provided to a person to whom the building product is supplied so that they can use it in a way that does not represent a risk of the kind described in those risk management factors. Section 8G has specific penalties, again, penalty units associated with the requirement for the provision of information. Section 8H specifies a duty to actually notify the Secretary of non-compliance or a safety risk where a relevant person for a building product becomes aware of one or more of the matters specified, being that non-compliance risk exists or a safety risk exists. There's also a suite of provisions allowing for voluntary recalls in respect of building safety or building products which may represent a risk. I don't propose to go through all of those, and obviously, as it is voluntary, the legislation doesn't actually stipulate you must exercise a voluntary recall in these circumstances, because obviously it would not then be voluntary. But nonetheless, where you have a situation where a supplier apprehends that the product may be a risk of the kind prescribed by the Act, it may very well be necessary to give consideration to a product recall. Now, obviously, this is directed to suppliers of major items, and obviously the recent cases concerning the bench tops that created all those risks associated with the installation when they were cut, mesothelioma and those sorts of things, were very much front of mind when these sorts of provisions were enacted. Can you go to the next one, please? Yes, okay. So, another significant part of the legislation is the introduction of a suite of measures concerning what are described as building product safety notices. And Section 9 stipulates what the types of notices are. This might be a building product warning, building product supply ban, a building product use ban, or a building product recall. The various divisions of Part 3 then go through exactly what each of those notices require and when they must be issued. They are issued generally by the Secretary, and they are usually in and around a circumstance where a non-compliance risk exists or may exist, or a safety risk exists or may exist. And obviously, these notices are in effect levelled so that at the start one has warnings, and by the end one has recall, depending upon the nature and extent of the risk that the Secretary apprehends exists or may exist with respect to the particular building product. Again, the various divisions 2, 3, 4 and 5 set out the circumstances for the issue of such notices and what one must do if one receives such a notice, and Division 7 talks about the penalties that are involved with respect to those notices. Thank you. Further provisions that have been introduced by the Amendment Act in the Building Product Safety Act concern unlawful conduct, show cause notices and trading prohibition orders. So if the Secretary is concerned about a recalcitrant or recidivist party who continues to supply building products despite notices and show cause notices, etc., and has committed repeatedly unlawful conduct, the Secretary can issue a show cause notice under Section 41B and make application to the New South Wales Supreme Court under Section 41C for a trading prohibition order, which will, as the name suggests, prohibit that person from actually trading. Now, those provisions, the order may be expressed to operate in one or more of the following ways, and it can be to prohibit the person from carrying out the business of supplying building products generally or in relation to a specified business, or it could be to prohibit a person carrying on a business of supplying building products as part of or incidentally to the carrying on of another business. it may be limited in time or it may be indefinite. And the Supreme Court is to make such an order under section 41C subsection 2 if satisfied that the person is likely to engage again or to continue to engage in unlawful conduct relating to the use or supply of a building product. So obviously what the Supreme Court is concerned with respect to one of these orders is the potential future conduct for a person that is subject to one of these show cause notices and applications by the Secretary. The history is obviously important because that may inform the approach that will be engaged in the future. But, as I say, section 41C2 requires the court to be satisfied about the likely future conduct of any person subject to one of these orders. There are further provisions in respect of the powers for investigation, or which used to be known as investigation, with respect to building products. So, as I've indicated in the slide, one of the changes, and it may be cosmetic, although it may obviously indicate a more fundamental change of approach, is that Part 7 of the Building Product Safety Act is no longer called investigative powers, it's simply called powers. Now, the purpose of those powers is to, again, assess whether a non-compliance risk exists or the intended use of a building product would be unsafe. The relevant powers allow an authorised officer to give a person a direction for one of or more of the following purposes, and again, you won't be surprised by these purposes, that is to prevent the use of a building product in a way that poses a safety risk, to eliminate or minimise safety risk posed by an intended use, to prevent, eliminate or minimise a non-compliance risk, and to conform to the Act. That's section 46 capital B of the Building Product Safety Act as introduced by the amending legislation. The nature of the direction may be of wide scope. There may be certain limitations to it. It may be oral, although if it is oral and not complied with, it needs to be confirmed in writing 7 days after. And again, there are a suite of offences which arise in the event of non-compliance, which give rise to the penalties associated with those penalty units that we were talking about earlier. Lastly, with respect to this part of the legislation, and I'll move on so that I can talk about some of the cases that I indicated earlier, there is a suite of powers for seizure and forfeiture in respect of building products. So it is possible, if a relevant authorised officer believes on reasonable grounds that a non-compliance risk exists, a safety risk exists, that seizure is necessary to determine whether a non-compliance or safety risk exists or an offence against the Act has been committed, to actually seize product from a building site and to remove it and to place it into custody. Now, there are a series of provisions which set out what is to then be done with that building product. There is an obligation on the part of the Secretary to return the seized building product unless it is established that there are grounds for not returning the seized product, and those grounds are set out in section 53 capital D, and I won't go through all of them, but again it relates to safety risk, risk of harm, the lawfulness of the product, and whether it's practicable to return it to the owner at all. I did say lastly, but this really is lastly. What I just wanted to note is that you may be aware under the Building Product Safety Act that there is a liability on the part of directors for corporate offences. These amendments expand that liability with respect to these issues of product safety steps and effectively oblige a director of a company to ensure that product safety steps are taken, which involve things such as action to obtain and maintain an up-to-date understanding of building products for which the corporation is a person in the chain of responsibility, and ensure that the corporation is appropriately resourced and has appropriate processes in relation to potential safety risks and non-compliance risks. There are other changes made, as I've indicated, to legislation such as the Design Building Practitioners Act, the Strata Schemes Management Act, and the Building Certifiers Act. I won't go through those given the constraints of time, but they are certainly important for you to be aware of in terms of those legislative matters which apply to all or many construction projects in New South Wales. So this is an important omnibus piece of legislation which addresses various statutory provisions in respect of the governance and performance of construction work, particularly in the course of the work. It does not give rise largely, and to the extent that I've been able to identify at all, any sort of causes of action of a private or civil nature between those that might be affected, or there is a reference to the ability to obtain compensation in the context of a trading prohibition order that I spoke about earlier. But generally, these are provisions which are intended to be enforced by the Secretary, by the state, by the application of penalty against corporation, individual and director to ensure or improve the quality of construction, particularly the quality of building products being used in New South Wales. So that's the legislative start to the year. Can I then go on to the first case that I wanted to speak about, which is the owners of Strata Plan 84674 and Pathburn. Doubtless you've heard about this decision. It came down late last year and was something of a thunderbolt with respect to the Design Building Practitioners Act and all of the fun and games we had identifying 58 concurrent wrongdoers in respect of every building claim, including every subcontractor's subcontractor and their dog. So this was a decision of the President, Justice Ward, Justice Adamson and Justice Baston. I should indicate at this stage that I am aware that an application for special leave has been made from the Court of Appeal's decision, so it may not be the end of the matter. Whether or not special leave is granted, well, that's a matter for the gods. So who knows how the minds work on Mount Olympus, but doubtless we'll hear about it in due course. But the short facts are that the owners allege that the builder and the developer breached the statutory duty under Section 37, and in answer to that claim, the defendants asserted that it was apportionable, as has been done quite conventionally prior to these decisions, and that 9 independent contractors were concurrent wrongdoers pursuant to Part 4 of the Civil Liability Act. Now, I think it is important at this stage to at least focus on, to a certain extent, what the pleading was, because when one comes to the reasons, it seems that there's something of a disconnect, because whilst many of the 9 independent contractors, so described in the Court of Appeal decision, were indeed subcontractors to the builder, there were parties that were not. So, for example, the defendant's architect was nominated as a concurrent wrongdoer. Whilst, as I say, the builder's tiling subcontractor, waterproofing subcontractor, and their tradesperson, together with the formwork subcontractor, were also nominated as concurrent wrongdoers. And when we come to the rationale in that decision, one can see why issues of vicarious liability and non-delegable duty may have applied to them. The council was also nominated as a concurrent wrongdoer on the grounds that it had approved the plans now said to be non-compliant with the BCA and the fire safety laws. The developer's certifier was also identified as a concurrent wrongdoer on the grounds that they had wrongly issued the construction certificate and the occupation certificate and had erroneously allowed or passed critical stage inspections for the work. Now, as we shall see, the reasoning of the Court of Appeal largely focused on the traditional analysis associated with non-delegable duty between employer and employee, and effectively drew an analogy and said, well, if an employer is liable for the employee's negligence, and that's been the traditional position, then having regard to the fact that the statute says that the duty is non-delegable and the Civil Liability Act provides for vicarious liability, it's hard to see how a builder can assert, in answer to a claim of breach of the duty under Section 37, that it isn't responsible, it was my subcontractor. And one can see the line of that logic. Where it becomes a little bit more difficult, I think, to reconcile is where you are dealing with apportionable claims, not with respect to builder and its subcontractor, but builder and some other person that's had a role in the actual construction process. Because there's no doubt they would, well, I shouldn't say no doubt, it can be easily envisaged that that person would also owe a duty under Section 37. So if there was a separate duty, say owed by a registered engineer in respect of certain work, structural work for example, and the builder proceeded with that work, not having retained the engineer on a construct-only basis, so the builder had no design responsibilities under its remit, and the evidence established that the work was defective both because of inadequate design and construction error, then for my part at least, and I may be getting a little bit out over my skis on this one, I don't see why the builder in that case couldn't call in aid the apportionment provisions of the legislation, because they are separate duties, they relate to separate activities, and they relate to separate causes of the loss and damage, which, in my hypothetical, is the subject of the claim by the plaintiff. But and so this case, I suppose, needs to be considered at least aware that it was a pleadings fight. It was an interlocutory stoush over pleadings. I've not seen the pleadings. I don't know how good they were. I'm sure they were excellent. But the rationale, or at least thinking, needs to be considered in light of those matters. Now, the President, Justice Ward, agreed the appeal should be allowed and that the orders proposed by Justice Baston should be made. Her Honour stated that as the duty of care in Section 37 of the Design Building Practitioners Act is non-delegable by operation of Section 39, this excludes by necessary implication the apportionment provisions of Part 4 of the Civil Liability Act. Justice Adamson, in similar terms, held that the primary judge erred in concluding that the legislature intended to limit the operation of Section 5Q of the Civil Liability Act to claims at common law. Section 5Q was an important issue in the decision because it was the provision which allows for vicarious liabilities for claims in tort. And what was held at first instance was that, well, the claim for breach of the duty under Section 37 concerns a statutory matter rather than a common law matter, therefore it's not a claim in tort. The Court of Appeal disagreed and said that the word or concept of tort is not so narrowly confined and can and has historically encompassed claims for breach of statutory duties. Justice Adamson held that Section 37 evinces a clear intention to extend the scope of the common law duty and that the person to whom the duty is owed is entitled to damages for breach of the duty as if the duty were established at common law. The fact that Section 39 stipulates that the duty may not be delegated is sufficient to exclude Part 4 of the Civil Liability Act, and as I say, there is no basis for a restrictive or confined reading of the words tort or duty of care in Section 5Q of the Civil Liability Act. Justice Baston effectively applied a similar reasoning, but with some more extensive consideration of the concepts of law, but effectively, as I say, held that similar to a circumstance of an employee and employer, a builder is liable or should be liable for the loss caused by its subcontractor. He held that a non-delegable duty is a mechanism for rendering a principal liable for the failure of its independent contractor to take reasonable care. The party owing the non-delegable duty is liable for the whole of the loss suffered. Part 4 does not prevent a person from recovering from an employer the economic loss caused by an employee for whom the employer was vicariously liable, and in the same way, it could not be called in aid by a builder to avoid responsibility for the negligence or breaches of duty committed by its subcontractor. As I said, that's all very clear and I think logical when one is dealing with a builder and its subcontractors. Where I think the case still has, or perhaps doesn't go as far, and there will still need to be some consideration given, is whether or not the traditional solidary liability, that is to say joint and several liability, that existed before the introduction of the apportionment regime under the Civil Liability Act applies generally, so that anyone who owes a duty under Section 37 is liable in whole for all of the loss associated, or whether, as between those who have breached the duty in perhaps different ways relating to the design, certification, construction, as between those parties, it can be said that apportionment can be called up, because there's no question, well, at least I think it's reasonably arguable, that there's no question that if a builder has no design responsibility, he is not delegating design responsibility or delegating the duty in respect of design, where some other party enters into the preparation of that design for the performance of certain building works. I notice the time, and I don't want to deprive my colleague of as much as can be done. What I'll try to just hit the high notes with respect to the civil decisions. The first one concerns, in short terms, a notice to produce. What occurred was CROs commenced proceedings against civil in circumstances where civil had obtained a couple of adjudication determinations that were worth together around about $2 million. CROs alleged that, or at least I should say pleaded, that a stay should be ordered pending the final proceedings being heard, because it contended there was a risk that if it paid the money, it would never see that money again. The particulars to that allegation were, particulars will be provided after discovery, subpoenas and in evidence. So they basically had no particulars at all for the contention. There was some argy-bargy concerning production of documents, some material was produced. At some stage, Civil decided to try and nip this in the bud and put a statement on from one of its accountants saying, look, here's a profit and loss statement, or draft profit and loss statement, I should say, draft balance sheet, which was produced by the functionality available under their Amaya business accounting software. It shows we're in rude financial health, go away. CROs said, well, that's all very interesting. We'd now like access to your entire books and accounts for the company to test whether or not those statements are in fact accurate or not. At one point, then having perhaps realised that it had gone too far in an unnecessary way, given that it bore no onus, Civil said, no, forget that, we're not reading those affidavits, we're not going to rely on any of that, you can just prove it however you like. CRO said, no, you've issued that, and we now want all of your material. And not only that, we want you to produce it in a particular format on a thumb drive that will enable us to interrogate all of your financial affairs for the last 3 years. As you can imagine, and this was by way of a notice to produce. This was not discovery or anything else. This is just a notice to produce. A-Civil wasn't particularly happy about that, and they were even more unhappy when the primary judge said, yeah, you've got to hand it over. So it went on appeal. In short terms, the importance of this decision is for a couple of reasons. Number one, a party who seeks to establish that a stay should be granted on grounds of the insolvency of the recipient of a payment has an extremely heavy burden, and it must almost prove certainty as to the circumstance of non-refundment. Secondly, the principles and policy of the Act apply, and importantly, the Court of Appeal took up what Justice Ball said in Kennedy Construction, where it was observed that the legislature, by section 32 capital B, had determined that the defining event for use or otherwise of the Security of Payment Act was liquidation. And anything short of liquidation, the legislature had said, well, it's all on, go your hardest. Doesn't matter if you enter in a deed of company arrangement, doesn't matter if external administrators are appointed, you can still use the Act, is a pretty clear marker that you will not get this sort of discretionary stay. The third thing that the Court of Appeal said is that the court's processes for compulsory production and forensic disclosure should not be exercised in circumstances where there was such a thin, if non-existent, basis for alleging solvency. So you couldn't just bootstrap, as so often happens with security for costs applications, these sorts of things, saying, I think you're insolvent. No, we're not. Put the application on. We now have to get all access to all your documents. So it may have some broader application as well, although obviously security for costs is a far different scenario. The next decision, again, this is the reverse, C. Rose and A. Civil. This is the actual contest. This case, I think, you can take away is important for at least 3 reasons. Number one, it further narrowed the notion of the duty to consider and really sought to make it abundantly clear that this notion of a failure to consider is not usually capable of identification by simply saying, well, I raised this point, but the adjudicator does not seem to have expressly addressed it in the adjudication determination. Unless the point was absolutely central and needed to be met head on, otherwise you really could not deal with the application, then it's most unlikely you'll be able to establish a failure to consider. Further, some of the authorities in other contexts use phrases such as genuine consideration, a need to actively intellectually engage, to undertake some sort of grappling with the submissions. The Court of Appeal said, that's all gloss. Not interested in your adjectival analysis. You need to show this was a central, pivotal point, and the only way it could not have been addressed in this adjudication if it was simply not considered. And that's rare. And they actually use the term rare in the decision. The second important aspect of this case is that there is a line of authority that you might be familiar with, which started at least, it was believed, although when one actually goes back and looks at the judgment, it was only one of the 3 Court of Appeal judges, that an adjudicator could not simply, quote unquote, rubber stamp a payment claim. So that if a payment schedule said nothing by way of reason for depriving payment or resisting payment, or it said 2 things and nothing more, then the adjudicator was required to at least go further on the observations in Coordinated Construction and J.M. Hargraves of Justice Hodgson to say, well, you still have to be satisfied that the work was done and it had a value. Now, the Court of Appeal said, no, you don't. The adjudicator doesn't do that. The adjudicator is there to adjudicate the dispute. The dispute is what is established by the terms of the payment claim and the terms of the payment schedule. So if the payment schedule says nothing, there's no dispute and the adjudicator can just award it. If the payment schedule simply says X and the adjudicator rejects X, the adjudicator need do nothing more in making a finding that the claimant is entitled to the amount claimed in the payment claim. So that whole line of country, Coordinated Construction, Hargraves, Pacific General Securities and Solomon, Acciona Infrastructure and Chess Engineering, Lang O'Rourke and Montfort Group, just to name a few, have all been held to be incorrect and overruled. So if someone comes to you and says, I don't think the adjudicator did anything other than reject the respondent's reasons and he should have done more, you can say, well, no, he shouldn't. He didn't have to do anything more. Now, lastly, in respect of this case, this decision of C. Rose and A. Civil was the first case, both at first instance and on appeal, that dealt with the new power under Section 32A of severance. Before the introduction of Section 32A, if an adjudication determination was affected by jurisdictional error, it went. There was no such thing as partial severance or anything like that. So even if it only affected a very small part of the adjudication determination, the whole thing went. Now, some of the judges were coming up with some fairly imaginative ways to get around that, but the legislature has fixed it for them. Now, this decision is worth reading as to how that application is to be run and what the court needs to consider. So the court doesn't need to look at reasons, it doesn't sever reasons, it simply severs that part of the adjudicated amount and may make consequential orders, I should say, for costs, interest, etc., based on what was disputed, what the adjudicator had to find, and what the adjudicator found which was affected by jurisdictional error, and to the extent that the rest is unaffected, either because it was conceded by a payment schedule or the adjudicator's reasoning or analysis did not suffer from that error, it should all be confirmed. I'm sorry, Brienna. All right. I won't worry too much about Demex because I lost. But it's, you can read it if you want. The other one that I just wanted to quickly touch upon, because it actually is interesting from a couple of points of view, is a thing called Fort Sydney Carlingford Development and Fort Sydney Carlingford Pty Limited. This is interesting from a number of perspectives. Number one, it was in the full federal court, which rarely has an occasion to look at the Security of Payment Act. But secondly, it related to an injunction preventing a party from resubmitting a payment claim to adjudication after it already had two goes and one was unhappy with the adjudication determination as it had been received. The lawyers on the other side were very smart and said, well, there's an authority called Cardinal and Hanover, which says that an adjudication which suffers jurisdictional error is void for all purposes. It's not a determination at all. Therefore, there is no determination issued within the specified time, even though one that purports to be has been. Therefore, I can just withdraw my payment claim and resubmit it. And presumably you can do that as many times as you like until you get a decision that you want. Declan Byrne and I went up to the federal court and got an injunction at first instance, and we held it on appeal. Basically, again, I would commend reading it. It's worthwhile reading. Importantly, what the full federal court said is that an adjudication determination affected by jurisdictional error is not necessarily void for all purposes. It's a matter which the court needs to consider. It is not for a client or a claimant to simply say, I think it's void, therefore I'm going to go again. And also importantly, it followed the reasoning of the Court of Appeal in Dual Corp and said, once you've got a determination, that's it. The policy of the Act stands against the repeated submission of claims to adjudication until you get the determination that you're after. I'm sorry I've taken more time than I hoped, but I will hand over to my colleague Brienna now for her part of the presentation. So thank you very much.
Thank you, Frank. I'm talking about two cases that come from slightly earlier in the year of 2023. The first being Parkview Constructions and the owner's strata plan 90018. The appeal was decision, which no doubt many of you are aware of, and then JKN, or Owner Strata Plan 92450 against JKN, Para Pty Limited, and another Court of Appeal matter. So Parkview Constructions for Ward, Leeming and Simpson involved a property that was completed in 2014. The owners commenced proceedings in 2016. The list statement asserted there were defects in the work which were outlined in Annexure A, and included that the owners reserved the right to provide further particulars of the defects, which no doubt many of you draft your pleadings like as well. In 2021, the owners sought to amend the claim to include 3 further defects. Now, that was more than 6 years after completion. So there was an argument as to whether or not they were able to make such an amendment. The primary judge, His Honour Justice Stevenson, relied upon the honorati principle, and at 62 of that decision said, "I see nothing in the words of the Home Building Act to compel the conclusion that there is a separate cause of action for each defect constituting a breach of one or more of the statutory warranties." Now, you may be familiar with honorati, but just in case you're not, that's a 1989 decision which said that there was one cause of action for a breach of contractual promise, which will bar subsequent proceedings for different defects, even if those defects were not apparent at the time, in effect a res judicata issue. In Honeywood and Munnings, a 2006 case, honorati was followed, which in a Home Building Act matter, which essentially prevented the owners from bringing a later claim against the builder for new defects that weren't known at the time of the earlier proceedings. Section 18E was then amended to stop that from happening and to expressly provide owners with the ability to bring further claim for new defects. So in essence, in this case, the builder and developer asserted that the honorati principle had no application to claims to amend a pleading, as opposed to claims based on res judicata or other forms of estoppel. The builder also and developer also alleged that honorati had been overturned by amendments to the Home Building Act. As His Honour Justice Stevenson in effect said, there's one single cause of action in respect of the statutory warranties, and therefore allowed the owners leave to amend the statement to include the new defects. So in effect saying once you've commenced, you've protected your right under the limitation period, and you can add additional defects. I should also indicate that these were major defects that were in question. The builder and developer were not happy with that and appealed, and essentially the question was there a new cause of action by adding these new defects, or whether it was the same cause of action. The Court of Appeal ultimately held that it was one cause of action, but not because of honorati, but because the legislative regimes of the Home Building Act which depart from the general position, the position at general law. The single cause of action approach favours a plaintiff when it comes to amending pleadings, but also favours a defendant when it comes to bringing proceedings following a judgment. At 67 of the decision, the Court of Appeal said, "It is one thing to prevent a plaintiff advancing further claims against the same defendant arising out of the same contract where there has been a final judgment. It is another thing to determine in what cases a defendant to pending proceedings is entitled to rely on a limitation defence in relation to unarticulated claims by the plaintiff where there's never been a final determination between the parties." So, and they then further went on to say, an amendment to include additional defects will not give rise to a new cause of action because the cause of action is for breach of the same contract. This will not be the case, they said at 103, that if the plaintiff sues a developer and then out of time tries to sue against a builder, but that's because they're different causes of actions. That really flows from a logical point of view. And nor will it be the case if you're trying to include a new cause of action, such as negligence. So it's about the same cause of action, the same breach of contract. Now, interestingly, at 104, the Court of Appeal said, "I would reserve for further consideration the issue which would arise if the difference in the nature of the defects was acute. In the present case, nothing turns on whether on that because it was they were all major defects. But if there are arguments between major and non-major defects, that may not always be the case. The example given was if a plaintiff brought proceedings within 2 years of completion of the work, but only for major defects, and then much later sought to amend to include defects which were not major, in respect of which the defendants would have had a limitation defence. Further, this paragraph 104 of this decision is actually quite important. They said it says that the case squarely raises the point developed by the builder that it does not make sense to speak of a single cause of action where part of the damage is subject to a 2-year limitation and part of it is subject to a 6-year limitation. The court did not wish to express a view on the proposition that for the purposes of Section 65 of the Civil Procedure Act, the differentiated limitation regime has the consequence that a party may have one single cause of action for breach of contract for major and one single cause of action leading to minor. But that wasn't an issue in this case. So in effect, the Court of Appeal said, look, this actually potentially might be different. We're not going to make a decision on it, but it doesn't really matter for the purposes of our case. So in summary, what was held was that the claims were effectively breaches of contract, despite not being a direct contract, in this case being an owner's corporation. There's one single cause of action complete when a defective structure is provided, irrespective of the number of ways in which those defects manifested. The nature of the claim is that the building has not been provided in accordance with the terms of that contract. Where a successor in title sues a builder or developer under the Home Building Act, the proceedings is for a single breach of contract, and an amendment which does nothing more than introduce further departures from the building as promised will not give rise to a new cause of action because it's the same breach. And Honorati and Honeywood and Munnings do not, it's not an issue because the statutory modifications do not produce the result that there's a different cause of action. So in summary, there's one cause of action. But I think the most important thing and interesting thing, well, I should also say, what wasn't discussed was whether it was important or not that the owners had specifically pleaded that they reserved the rights to include additional defects. I would recommend that you include that anyway, just as a safeguard, but they don't actually go through that, whether it would be different if it didn't say that. One would think that if there's one cause of action, that's all you need, but perhaps to be safe, you should include those words just to avoid that fight. But I think one of the most interesting things is that is the fact that the issue of major and minor defects. And the example that they gave or suggested is that if a plaintiff brought proceedings within 2 years, but only for major, and then sought to include minor later, that might be different. I have a fundamental issue with that. I think that if you've commenced within the 2 years, you've preserved that position. However, I also think what's interesting is that if you are trying to add defects of a minor nature 6 years after the fact or 8 years after the fact, there'd be serious questions raised as to whether or not you can really claim for those, because as we all know, it's a very low bar in respect of minor defects. So one would think that that would have to be dealt with differently. We're not talking about serious structural issues at the property. We're talking about what might be a minor scratch, which no doubt would be an argument about maintenance issues and the like. But I do think there's something to be said about the nature of the defects, notwithstanding the fact that you may have preserved the right for, say, minor defects early on. If your case goes for 8 years or for whatever reason, I would have thought that it would be difficult to try and claim that those were in fact minor when they've only arisen 8 years after the fact. So that's just something from my perspective, but at the moment it's not been tested, and the Court of Appeal didn't actually make a decision on that. The second case is the JKN Para case that was before Gleeson, White and Brereton. It was an appeal from the decision of His Honour Justice Black. This case involves non-compliant cladding and the issues of reasonable and necessary rectification. But importantly, it also talks about the complexities of the National Construction Code and compliance with the National Construction Code, including the DTS deemed to satisfy provisions, which is one way to comply, or performance solutions, which is another. So in summary, the Owners Corporation's case was there'd been a breach of the statutory warranties, and that compliance could be established, could only be established by the deemed to satisfy or alternative solution, which was identified prior to the issue of the construction certificate. Now, in this case, no performance solution, this is in relation to cladding, combustible cladding, was shown prior to the construction certificate, and so the owners said, well, therefore it's non-compliant. They also had an alternative case that it wasn't fit for purpose because it was a danger to health and safety. Now, the respondent's case was that the building was capable of being certified at the relevant time by an alternative solution, but didn't identify what the alternative solution was, just said it was capable of being certified by one. Now, it was common ground the rectification cost was $5 million, so that wasn't in dispute. It was common ground that it didn't comply with the deemed to satisfy provisions, and it was also common ground that no alternative solution was prepared prior to the issue of construction certificate. At first instance, His Honour found that the cladding didn't comply with the deemed to satisfy provisions. The strict answer to whether the cladding was otherwise compliant by way of an alternative solution was no. But notwithstanding that finding, that there was no breach of Section 18(1)(c) on the basis that the Owners Corporation had not established that an alternative solution could not then or now be performed. In addition, no breach was established because the evidence did not show the cladding was combustible for the purposes of the BCA or in a general sense. And but had it been established that there was a real risk of the fire spreading, that His Honour would have considered that the statutory warranties would have been breached, and essentially couldn't find from an evidentiary point of view that the combustibility had been proven, and even though that His Honour considered that loss and damage did not arise, the Owners Corporation had the onus of proving that an alternative solution could not then or now be performed, and that rectification works at a substantial cost would not be proportionate to any benefit obtained. So on appeal, the builder and developer conceded a breach of Section 18(1)(c). Now, ultimately, just to hurry this up a little bit, the building was found that it didn't satisfy the performance requirements with respect to fire because it did not comply with the deemed to satisfy provisions, and no alternative solution was prepared prior to the construction certificate. That was the first thing. The second thing being the burden of proof of establishing loss lies on the claimant. By contrast, the party in breach of a contract has an evidentiary onus of displacing the prima facie rule for assessing damages as the cost of, essentially show that the cost was unreasonable. So the Owners Corporation didn't acknowledge that it had the onus of establishing that no alternative solution would be possible at the time of the issue of the construction certificate, or would have been possible now. Now, having established that respondents did not comply with the BCA, the Building Code of Australia, the OC was not required to go further to proving that the respondents could not have complied by acting differently with respect to hypothetical alternative solutions. So in effect saying once the Owners Corporation proves they didn't comply, it's not up to them to show that they couldn't comply in any other meaningful way then or now. And in essence, since the respondents, the builder and developer, did not establish that the alternative solution would have been available prior to the issue or now. So in this essence, the builder and developer couldn't prove, well, there wasn't one before, but also couldn't prove that it was now available. The respondents did not discharge the evidentiary onus of establishing that the costs would be unreasonable. And then finally, that the builder and developer's failure to prepare an alternative solution in respect of the cladding was not merely a formal or technical breach, which did not warrant reinstatement of reinstatement damages. By installing cladding which did not comply with the performance requirements, the builder and developer provided the owners corporation with a building that did not meet the minimum standards for public safety, which they were contractually obliged to provide. So there's a couple of things important about this case. Firstly, about the onus of proof, and in particular in relation to remediation and reasonableness. And it also reinforces the operation of the Building Code of Australia, and that performance solutions should be issued prior to the issue of a construction certificate. Now, to the extent that there's a performance solution after the construction certificate, I think that this case would have been quite different. But the fact of the matter was there was no evidence that there was an alternative solution with what had been installed, and that was obviously a significant issue for the builder and developer.